Good morning. I've just been a little distracted texting. So, the last couple of live streams I did kind of started because I was looking into other cases related to my own complaint that I had filed with the disciplinary counsel and for the Attorney State Board in Louisiana, or whatever the right words are, you know what I mean. Um, yeah, I had done my own case and I was looking into other situations. Well, I had filed my own complaint and I was looking into other cases to see what recent outcomes have been like and what similar situations were. Whenever I found the suspension case related to Attorney Salvador Randazzo. So the first live stream we did on the Randazzo family was covering that case. That case discussed was basically about another case within the Randazzo family as it relates to business decisions with their corporation and their property and their land, and as it related to negotiating with St Bernard Parish about a different case. So today in this stream, I think I found that different case related to St Bernard Parish. So basically, Attorney Salvador Randazzo didn't want to settle with St Bernard Parish and had made this entire situation. I'm sorry, I am getting text messages that are distracting me right now. So Attorney Salvador Randazzo was near this situation. I can't speak. I'm so sorry. I got distracted. Excuse me. I'm just going to timestamp this. Okay. So, let me just try going at this again. I'm so sorry. So first we had looked at I'm just gonna drink my coffee. So first of all, I had been looking at similar cases to mine and other cases that are just recent filed with the Office of Disciplinary Counsel and what those outcomes were that were publicly made available. When I was doing that, I found the case against Attorney Salvador Randazzo. Whenever I found that case, we looked into it, and the reason he had gotten suspended was about a case that related to his family property. He basically was trying to prevent his family corporation because everybody else wanted to settle with St. Bernard Parish, and he was basically trying to legally prevent them from doing so, but that didn't work out for him. But the reason he claimed that he was trying to stop the family from negotiating with St. Bernard Parish was a different case with St. Bernard Parish. I think I found that case, and that is what we're going to cover today. So first we're going to look at the Randazzo family history in terms of what does everybody and everything have in common. And then we're going to look a little bit. So I was reading from a Randazzo family tree from a NOLA.com article, but I haven't actually read the article in these streams. So we're going to check out the actual article, and then we're going to get into two cases. One is what I believe is what the situation was about in the last live stream, where I was telling you, the St. Bernard Parish and his family had an altercation, and that reason was why he didn't want to settle with St. Bernard Parish. Well, we looked at the case related to his family corporation trying to stop him from settling with St. Bernard Parish already. Now we're going to look at why. What was that initial case with Randazzo and St. Bernard Parish, if I'm not mistaken. If this is the correct case, I think it is. I could be wrong. And then, last but not least, there was also surrounding all of this, I believe it could have to do with real estate succession from Salvador's father, Lawrence Randazzo, because a lot of these people are mentioned in this discussion, And there are also similar people when it comes to the appellees and the appellants in terms of another issue where I believe the family was having conflict. And so I just want to read this other case and see if that gives us more of an insight onto where the family division happened. Because from the last live stream in that case documentation, it looked like around 2018, 2019, the family seemed to be relatively unified, or at least if there was any dispute at that time, it wasn't made public, you know. So what was made public though were disputes after 2019, and that would be mostly disputes, if I'm not mistaken, after Mr. Randazzo's mother had passed, as well as his uncle, Mr. Manuel Randazzo, you know. And so I believe having these key family members pass on really made their descendants feel untethered, you know what I'm saying? Because what they had in common is no longer in this world, on our earth. I know we all have different spiritual beliefs, so that as well, I do believe, you know, in the spirit world, but not everybody does, and you know, so support whatever you believe, whether you're agnostic, atheist, Christian, Muslim, Jewish. I support your beliefs. I myself, my father is indigenous, so my beliefs tend to go towards more of my family connection there. But yeah, I support all people and their beliefs and everything. And so, but anyway, so I do believe though that having the second generation of the Randazzo family, some of the main stakeholders who are publicly known for being the face of the Randazzo King Cake family business, you know, having them pass on that second generation to where now it's more of the third and fourth generation in play. And I know not everybody in the second generation has passed. I believe some of the sisters are still alive, if I'm not mistaken. But I believe that having that disconnect in that family division, that was a source of unity that has gone away. And I do believe that what could bring everybody back together is remembering how we all came here to begin with, how you all came here to begin with, which is in terms of family, you know, and thinking back to the first Mr. Salvador Randazzo, and thinking back to what he wanted for his future, you know, because in my dad's family, like, we always think of and plan for the next future generations. We think of what is it gonna be for 7 generations in the future. And so for the Randazzo family, I hope that they have 7 more and further and even more and more generations of success for their Randazzo business. But I hope that they put that into practice by always starting to think of every decision they make, what is that going to mean for the next generation, and securing the future for the next generations, and not thinking of just what it means for themselves right now. You know what I mean? But yeah, anyway, I'm sorry, I'm rambling. So I'm going to roll my intro. I'm going to answer a text message, and then we're going to get this show on the road. So thank you for joining me today. Hi, my name is Alexis, also known as Lexie or Deaf Child. I was born deaf, hard of hearing. I began doing business as Deaf Child 2013, marketing 2011, sales 2009. I've earned 50 plus certifications in marketing and sales. My Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Deafness runs in my family genetically. Speech is not fully accessible to me. Anyway, I'm here to bitch about whatever the fuck is on my mind. So here we go. Visit my site at noladeafchild.com. Okay, so I'm going to try to totally focus. So what I first want to start off with is kind of leaving off with where I was in my little intro situation there, but I want to first show you what all 3 of the Randazzo family websites related to king cakes, you know, that I can find, have in common. And that is, you know, just kind of having that memory of what is what are the Randazzo family here for? How did we all get here? And you'll notice on every single website, they all talk about the source origin of that original bakery in 1965. So this is kingcake.com for the Randazzo Camellia City Bakery. Yeah, so this one, they discussed the Highland Bakery being opened in 1965. And this one, I believe, is from Manuel Sr.'s lineage from the Trisha Randazzo side right there. All right. And then we also have here from Nana Randazzo's Bakery. What's mentioned again? This is from Felix and Joel Randazzo Foray. So that's from Mr. Lawrence Randazzo's side, Mr. Salvador siblings, I believe. So they're here again. They mentioned April 1st, 1965, that Highland Bakery with the Camellia Club and the father and the brothers. They mentioned that here. All right, and again, what do we have here? This is the Manny Randazzo King Cakes right here. So the other one was from Patricia's side. This one's from Manny's side. The second and third, if I'm not mistaken, descendant. And here again, what do they have? Their story starts with family. They learned it from the father, Manuel Sr. here, who learned it from Salvador, if I'm not mistaken. And that would be the father and the brothers in 1665. Did I say 16? God damn, the fuck. In 1965. Manuel Sr., you know what I'm saying? With Randazzo's Highland Bakery in Chalmette, Louisiana. And they discussed, and then when he opened his full-service bakery, it was under the direction of his father. You know what I'm saying? And so the reason that I bring up all the 3 different family websites that we can see from the Nana Randazzo's Bakery, from Manny Randazzo's King Cake, and from the Randazzo's Camellia City Bakery, from the actual people who descend from Salvador Sam Randazzo. What do those 3 bakery websites have in common? That 1965 bakery. Their common ancestor, their grandfather, their aunts and their uncles, all connected. So when you look at that, you can't change who the fuck your family is. Yeah, we can go through stages of disowning. Like, my twin and I didn't speak for years. But we're working on our relationship again. But, we have certain differences in which I don't think that we can currently come to an agreement on. And so, it's not easy. But we are still working on our relationship because what future do we want our niece to have? Or her daughter, my niece? What, you know what I mean? What future do we want ourselves to have? It's extremely difficult when you're not born alone, you're born a twin, and then to walk in this world alone, But so for me, I understand family division, and I also understand family reconciliation. And I understand family reconciliation in multiple forms because my father, he is Native, and he has always known our history and pushed our family history in my brain. I've never not known my lineage. I've never not known my family history. But I have not always had a connection to my family culture or to my family, my distant relatives. That didn't begin until the recent years. You know what I'm saying? Because I had to go do that work to reconnect. So reconnection also is labor. And so it takes understanding of family history. It takes understanding of trauma. It takes understanding of social issues. And it also takes resources to be able to be in the mindset and have the space and time and energy to work on those things. But when you look at the family business and you think of this, I don't believe that the original Mr. Salvador Sam Randazzo would want the family to be divided this way. And I know that we don't know what is actually happening behind the scenes. There could be way more to it than this. But it does look as if on paper, it's kind of as if it's Mr. Salvador Randazzo, the younger one, against almost the rest of the family. So previously we have seen the legal disputes between Mr. Salvador Randazzo and the Mr. Manuel Manny Randazzo Sr. side when it comes to legal disputes, I believe, with the Torres family and whether or not Mr. Manuel Randazzo's widow, I believe, if I'm not mistaken, if I interpreted all of that correctly. Mr. Salvador Randazzo was basically kind of trying to, I think he was just trying to invalidate the decision that the corporation made, but in that context, he was also kind of attacking whether or not his family had the authority to make the decisions they were making. You know what I'm saying? So all of that kind of, we've seen how there were disputes between him and a lot of that side of the family. In the next documentation that we're going to look at, or in the last thing that we're going to look at today, actually, we will see where Mr. Salvador Randazzo also had a dispute with his siblings. So we've seen previously how he had a dispute with his cousins, so he's also not in a good place with his siblings, or at least he wasn't at the time of this legal documentation. I mean, hopefully maybe he is now. But yeah, so what I'm going to do now, though, is just fucking pull up. We're going to read this article. So previously we were looking at this Randazzo family business tree to kind of get an understanding of who the Randazzo family was. And the last two live streams, we used this as a reference point in the reading of the legal documentation to kind of track who was who. But now I just kind of want to read this actual article because we haven't actually read it, so I want to read the actual thing so we have a better context also. So, yeah, but it's called, Why Are There So Many Randazzo King Cake Shops? Here's the family history. Culinary dynasty began in 1965, now in 4th generation. And this is by Gabriella Killett, and it's from January 2024. Okay, so it says, the Randazzo family has held a storied place in king cake history for more than half a century, since Patriarch Salvador Sam Randazzo and his sons crafted their recipe in his St Bernard Parish bakery in 1965. But after his grandson, Manny Randazzo Jr., opened a Metairie bakery in 1992 and started selling king cake using the family's original recipe, criminal charges and lawsuits ensued. Here's a timeline of the bakers and their coveted carnival treat. 1965. Sam Randazzo opens Randazzo's Highland Bakery in Violet with his 3 sons. There, they make the recipe for his king cake. The bakery opens a Chalmette location about 6 years later. 1988. Sam Randazzo dies and leaves the business to his 3 sons, Lawrence, Manuel Sr., and Anthony. 1992. Manuel's son, Manny Randazzo Jr., opened his own bakery in Metairie, Randazzo's Fine Cakes and Pastries. 1993. Lawrence's daughter, that's the year I was born, Lawrence's daughter, Joel Randazzo Forget, opens Randazzo's King Cake Express in Chalmette. Her cousins, Tricia Randazzo Zorns, would open Randazzo's Air Express in Slidell soon after. September 1994. Lawrence's son, Salvador Randazzo, and his siblings open another Violet bakery, Good Children Bakery Shop, which also sells the original king cake recipe. Alrighty, so, if I'm not mistaken, this Salvador Randazzo right here is the same one who was suspended from the state bar. And if I'm not mistaken, Good Children Bakery Shop was destroyed in Katrina, unfortunately. If I remember correctly, I think it was that one. Okay, so December 1994. Oh shit! Families members slap and push each other during an argument. Domestic violence. It's always the white people, leading to misdemeanor charges and a lawsuit. 5 family members got into a name-calling spat turned physical. One of Lawrence's children, Lorene Randazzo, filed a civil suit against family members, alleging severe and disabling injuries, as well as severe emotional and mental distress. I don't know what happened, but because if she wasn't trying to fight and they attacked her anyway and she ended up getting hit, then I fully fucking support her pressing charges on them, because the fuck are you hitting her for, right? But like, you know what I do hate? And this is not about her because I don't know the situation at all. This is just separate speculation that this reminds me of. I hate when people start a fucking fight and then whenever they get hurt, and it's not a life-threatening or seriously disabling injury, it's just like, oh, a fucking bruise that will help, bitch, get over it. And then whenever they get hit, they want to play victim. That shit I fucking hate. And I've had that fucking shit happen to me where somebody wanted to start a fight with me and then act like I, clutched their pearls, acting like, they're some fucking grandma, fuck you, bitch. Anyway, so. I'm going to answer this text message and then we're going to keep going. Okay. So, but yeah, anyway, so obviously it got physical, and I wonder if I can find any documentation on that. I'm gonna look. So that got physical, well, not this stream, it'll be a different stream. If I do another stream on this, it'll be because I found out about that. So that got into a situation, you know what I mean? Alrighty, so in 1995, Lawrence files a lawsuit alleging that Manny Jr.'s Metairie Bakery cost Lawrence's shop almost $100,000 in king cake sales in 1993 and 1994. The suit is later dropped. So this, I don't understand, because you are all siblings, and there's so many king cakes, people making king cakes in New Orleans and Louisiana in general. I don't understand, like, this part. Like, your lack of marketing isn't your siblings' fault. I don't know how y'all gonna claim, you know what I mean? Like, y'all all use the same fucking recipes and shit. Like, that shit right there is bullshit. I'm glad that suit was dropped. Like, what was the point in that? Okay, so I'm over here talking about family unity and how I believe that perhaps it was the second generation where it fell apart after that second generation passed. But no, hold on. I was wrong. It looks like the problem started with the second generation. Look at this. You know what I'm saying? Because I didn't realize that before. I totally should have read this earlier and processed that better. Because look at this. Why is the second generation infighting like this when you know you all got your recipes and started this shit from your dad? You know what I'm saying? So I believe now that the third generation acting the way they are is learned behavior from the second generation, in my opinion. Anyway, so 1997, we got Manuel Randazzo Sr.'s daughter, Trisha Randazzo Zorns, and her husband, is that Louis or Louis? I don't know. Let's go with Louis. Louis Zorns opened Randazzo's Camellia City Bakery in Slidell. In 1998, Lawrence dies at age 72. May he rest in peace, but damn, he was old. I didn't realize y'all were that old, man. But you know, it does give you hope. You're never too old to start a business. You know what I'm saying? Like, to put that in a timeline, that means, you know, they were in their 30s and 40s and 50s by the time they were getting their own bakeries, if I'm not mistaken. Or 60s and 70s. Like, I don't know, man. I don't know how old these people were, but look, it looks like they were like just much older than I thought they were. No offense. Old people, I respect old people. I'm gonna be old one day. I'm getting old. I'm like middle-aged, I guess. Is 30 middle-aged? I guess I'm middle-aged. I don't know. I'm 31. Fucking, alright. So 2005, Anthony dies at 81 too. See, that's why the fuck I said y'all were old though. My bad. Anyway, August 2005, Hurricane Katrina destroys Good Children Bakery and Randazzo's Camellia City Bakery. Later, Randazzo's Camellia City Bakery reopens in preparation for the 2006 carnival. So my last name's Carney. I like to say my life is a carnival. Yeah. Anyway, you can't have a carnival without a carny. But, okay, so 2006, Forget opens Nana Randazzo's Italian Bakery and Cafe in Covington with her husband. 2008, Manny Jr.'s ex-wife Diane Randazzo opens Diane Randazzo LLC Bakery in Elmwood. Manny Jr. files a lawsuit, and the judge rules she may not use the Randazzo name. The bakery is now called Caluda's. I do support that. Like, okay, so with this other lawsuit where Lawrence was trying to sue Manny, I did not support that because, bitch, you both know you got that from your dad. But with this, like, okay, on one level, right, no disrespect to Miss Diane, but it's like that's not your family inheritance, and so to try and profit off of a legacy that wasn't yours, that you didn't necessarily build, because you know what I'm saying? Like, that was something the brothers and the father did. Like, in my understanding of the timeline, I don't believe she was, if she was part of that, it just wasn't published publicly to my knowledge yet that I have found. But anyway, so like if she had no part of that, you know what I'm saying? And yeah, I just believe like it does not take away from the work she did do though. Like, and her knowledge and her abilities in baking. I believe, like that is like she could still use that as a reference point for her experience, but then build on something new so that way it's not profiting off of their legacy, but making her own legacy. I actually think it's better this way because why would you want your legacy to be based on your ex-husband's when you can have your own? You know what I mean? But at the same time, they did have children together, so that family name also would be, if it was for the children, I feel that would be more of like, but then again, Manny had his own thing too, so it's not like, you know what I mean? Okay, I'm like not even forming complete sentences. Read my fucking mind. Whatever, let's keep going. Okay, so 2011, a second Nana Randazzo's Italian bakery opens in Chalmette, run by fourth generation Kayla and Felix Forget. So that's 4 generations from the Randazzo family in the king cake business. Isn't that adorable? I love that. So cute. January 214. The fuck is wrong with me? January 2014, Nana opens its 3rd storefront in Mandeville. And in June 2019, Manuel Sr., the last surviving son of Patriarch Sam Randazzo, dies at 91. So, previously, the legal documentation that I had found all seemed to look at where I was seeing a lot of the disputes. In that dispute, they were saying that they were on good terms before 2019, from my understanding. In the last live stream, whenever we were looking at the dispute between Salvador Randazzo and his family with the Randazzo Corporation, in the footnotes, it discussed that around 2019, they were still on good terms, if I'm not mistaken. Or at least they were on the same side of some legal documentation. But then, somewhere between that time frame and now is whenever they started having public legal disputes again recently within that 3rd generation. And so, yeah, I previously thought that perhaps it had to do with the passing of the last surviving, some of the last surviving members of the Randazzo family, and perhaps it had to do with grief from parental passing as well on the Salvador side. Like perhaps it had to do with grief on both sides because the timing was pretty close there. But after this timeline and looking at the fight that happened in 1994, was it? Yeah. I'm now starting to think that this is because this was a second and third generation altercation combined, but between this December 1994 altercation and between the lawsuit filed by Lawrence in 1995 against his own nephew, I do believe, like, when you look at these situations, that the issues the third generation is having are behaviors that they learned from the second generation. You know what I'm saying? That's just my opinion, though. But yeah, okie dokie. So next up, what we have here, this is just kind of like the case summary for the background and the issues on what was the issue between Randazzo family and the St Bernard Parish Government. And the reason we are looking at this is I believe that this is the case that in our last live stream that we covered, Mr. Salvador Randazzo was basically going apeshit on his family, the Randazzo Corporation, to put it in a rough summary, trying to legally stop them from negotiating with St. Bernard Parish. And the reason he was saying that he didn't want them to negotiate with St. Bernard Parish or to settle with them in that case was because of what I believe is this case that we are about to read now, and that's why we're reading it. So, this is Randazzo versus St. Bernard Parish Government. This is from 2017, it looks like, and it says the background here. Appellant Lorene Randazzo owned a Chalmette, Louisiana home damaged in Hurricane Katrina. St. Bernard Parish condemned the property and ultimately demolished it in February 2011. The appellant sued St. Bernard Parish's contractors, Baroka and Benura Engineers and Consultants, LLC, and Unified Recovery Group, LLC, and insurers, Houston Casualty Company, Scottsdale, AIG Specialty, alleging improper condemnation or demolition and lack of legal notice. Defendants moved for summary judgment. Motions filed 2014 through 2015. Several exhibits attached were selected pages of depositions taken in unrelated lawsuits. Appellant had no notice of those depositions and could not cross-examine the witnesses. The district court granted the summary judgments in open court, September through November 2015. The appellant appealed. On appeal, the court considered pre-2016 Louisiana Civil Code Procedure Article 966 Summary Judgment Standards and Louisiana Civil Code Procedure Article 1450 Use of Depositions when evaluating admissibility and effect of the out-of-case deposition excerpts. Issues. So, I'm going to read the issue, the plaintiff's argument, and the defendant's argument, and what opinion got held. So for the issue of admissibility of deposition excerpts taken in other lawsuits, the argument was that excerpts are inadmissible because the appellant lacked notice and an opportunity to cross-examine the deponents. It says the deponents. I've never heard that word before. I'm guessing that means the people who were deposed. I don't know. Anyway, the defendant's argument. Excerpts are proper summary judgment evidence. Appellant did not contemporaneously object. Court held admission was error. Louisiana Civil Code Procedure Article 1450 requires presence, representation, or reasonable notice to use another case depositions. None existed here. As to the issue of contemporaneous objection requirement, the appellant's filings and oral statements at hearing sufficiently put the court on notice of the objection. The defendants asserted appellant failed to make a contemporaneous objection, barring appellate review. Court found the district court was on notice. Transcript shows objection raised, and therefore reviewed admissibility on the merits. As to the issue of prejudice from admission, right to cross-examination, the admission deprived appellant of meaningful opportunity to cross-examine, substantial right affected. The defendants implied any error was harmless or cured. Court held denial of cross-examination was prejudicial. Importance of cross-examination in civil cases mandates reversal. As to the issue of sufficiency of remaining summary judgment evidence, the appellant argued no admissible evidence showed absence of factual support for her claims. The defendant relied on the deposition excerpts to show no genuine issue of material fact. Without the proper deposition excerpts, defendants failed to carry their burden. Summary judgment reversed and case remanded. And then here it's got the key cases cited, but I'm not reading all that, but it's there. Okie dokie. So now let's get into the actual case itself. And this was against Randazzo versus St Bernard Parish Government. So basically, I believe because St Bernard Parish demolished Mr. Salvador Randazzo's mother's home, Mr. Salvador Randazzo didn't want to negotiate with them, if I'm not mistaken. And I believe the reason for that could be perhaps related to grief, because at that timing of all that going down, she had passed relatively recently. I do believe he was potentially feeling untethered from the passing of both of his parents, if I'm not mistaken. Like, no matter how old you are, you need your fucking mom and dad. I don't give a shit. You could be 100 years old, you still need your mom and dad. Alrighty, so, the actual case here, Randazzo versus St. Bernard Parish Government, on the side of this document, it says reviewing motion for summary judgment. Reversing district court's grant of summary judgment in favor of defendant contractors and insurers in homeowners' improper condemnation and demolition suit. And remanding because evidence from depositions taken without notice or cross-examination opportunity was improperly admitted. So, this is a little confusing to me because here it's calling the homeowner's lawsuit improper. Oh, I think it's saying that the condemnation was improper. Alrighty, so I think here this is a motion where they decided to reverse. So basically, here's what I'm not understanding though. The house was demolished, if I'm correct, in like 2011. But in 2017, they're legally reversing the judgment for that. But how does that make any fucking sense when the house is already gone? Is that for damages to be awarded? Is this about money? I'm just asking for the class. I don't know shit about the law. Anyway, okay, so what the actual case here says though, getting into it, let me zoom, can I zoom in more? So, it says, it's from, I believe it's under the, jurisdiction of Judge Joy Cosick Lobrano. Perhaps I'm wrong, but I don't think I said that right either. So anyway, it says Lorene A. Randazzo, appellant, and that would be Salvador Randazzo's mother, if I'm not mistaken, the widow of Lawrence Randazzo, and I believe she may have passed on now, if I'm not mistaken. So Lorene A. Randazzo, appellant, appeals the district court's judgments granting 5 motions for summary judgment against her. Finding that the district court erred in granting these motions for summary judgment, we reverse the judgments and remand the case to the district court. Appellant was the owner of a home located in Chalmette, Louisiana. Appellant's home was damaged during Hurricane Katrina. Because of the damage the home suffered, St. Bernard Parish, SBP, condemned the home in August of 2008. After the initial condemnation of the home, appellant was successful in having her home removed from the condemnation list for several years, until it was again condemned by St. Bernard Parish in January of 2011. The record does not indicate that appellant ever made the required repairs to the home to get it removed from the condemnation list. Appellant received the final condemnation letter on January 26, 2011, and the home was demolished on February 28, 2011. On February 2004,
what am I saying, February 2004? What the fuck is wrong with me? On February 24th, goddamn, 2012, appellant filed a petition for damages stating that, okay, so it is for money because that's what damages are, right? But this is what I don't understand. Like, how does that make sense? How the fuck, because, like, well, I guess it's less than 60, like, this is like a final condemnation letter, and then it was, demolished less than 30, right over 30 days later. So if you get a final condemnation letter, I don't know legally, does that mean you have no legal option to try and fix the place? Does that mean it's a done deal 100%? Because if so, then I could see how, like, I would think that why would they have any legal recourse, you know what I mean? If they had so many chances to fix it, then they got the final notice and that's the procedure, right? But if that's not the case and you're still supposed to have a chance to fix it then like literally not having 30 days just to fix it is kind of fucked up, right? Like, cause you know what I mean? Like, I don't know what that means, right? Like, I don't know. Yeah. Anyway, okay, sorry. So, on February 24th, 2012, appellant filed a petition for damages stating that St Bernard Parish, its contractors, Baroka and Benura Engineers and Consultants, LLC, BBEC, and Unified Recovery Group, LLC, URG, and their insurers, Houston Casualty Company, HCC, Scottsdale Insurance Company, Scottsdale, and AIG Specialty Insurance Company, ASIC, were liable for the improper condemnation and demolition of her home. Specifically, appellant asserted that she never received legal notice of the condemnation. BBEC, URG, HCC, Scottsdale, and ASIC all filed motions for summary judgment between October 24, 2014 and January 15, 2015. In response to claims filed against URG and BBEC, URG and BBEC submitted parts of a deposition taken of Jerry Graves, the Chief Administrative Officer of St Bernard Parish, given in June 2012 in another case as an exhibit to their motion for summary judgment. The parts of the deposition that were submitted stated that URG was not involved in any of the decision-making processes with respect to condemning a home. Instead, Mr. Graves stated that URG was solely responsible for any demolition work that was issued by SBP, which is St. Bernard Parish. Selected portions of a deposition of Anthony Gray Dillon and selected portions of a deposition of David E. Peralta, both taken in a case other than the one sub judice, were also admitted. The insurer defendants, HCC, ASIC, and Scottsdale, adopted these exhibits by reference. It is undisputed that appellant was never noticed of these depositions or given the opportunity to cross-examine the deponents. But also, why would you be noticed of a deposition that wasn't your case? You know what I mean? But yeah. Anyway, okay. So, and then it says LAII. I don't know what the fuck that means, to be honest. Is this Louisiana too? LAII? I don't know. Of the summary judgment, motions were granted by the district court in open court on September 18, 2015. Oh, maybe it's supposed to be all, and this L is a typo. I don't know. I'm going to read it that way because that makes sense to me. All of the summary judgment motions were granted by the district court in open court on September 18, 2015. Written judgments were signed as to URG, ASIC, HCC, BBEC, and Scottsdale between September 29, 2015 and November 20, 2015. From these judgments, appellant timely appeals. Appellees filed their motions for summary judgment prior to the effective date of the 2016 amendments to Louisiana Civil Code Procedure Article 966. As a result, the version of Louisiana Civil Code Procedure Article 966, effective prior to the amendments, applies to these motions. The summary judgment procedure is favored in Louisiana. Louisiana Civil Code Procedure, Article 966A2. The motion should be granted if the pleadings, depositions, answers to interrogatories, and admissions, together with the affidavits, if any, admitted for the purpose of the motion for summary judgment, show that there is no genuine issue of material fact and the mover is entitled to judgment as a matter of law. Louisiana Civil Code Procedure, Article 966B. 2. Regarding the burden of proof on summary judgment, Louisiana Civil Code Procedure, Article 966C2 states, the burden of proof remains with the movant. However, if the movant will not bear the burden of proof at trial on the matter, that is before the court on the motion for summary judgment. The movant's burden on the motion does not require him to negate all essential elements of the adverse party's claim, action, or defense, but rather to point out to the court that there is an absence of factual support for one or more elements essential to the adverse party's claim, action, or defense. Thereafter, if the adverse party fails to produce factual support sufficient to establish that he will be able to satisfy his evidentiary burden of proof at trial, there is no genuine issue of material fact. Then it says, appellate courts review a grant of motion or summary judgment de novo using the same criteria district courts consider when determining if summary judgment is proper. Can anybody else see all of these typos? Because what the fuck, man? Anyway. In her first assignment of error, appellant argues that the district court erred by allowing appellees to attach selected pages of depositions taken in other lawsuits as an exhibit to their motions for summary judgment. Appellant argues that she was not given notice of these depositions or the opportunity to cross-examine the deponents, and thus her substantial rights were affected by the deposition's admittance into evidence. Error may not be predicated on a ruling that admits evidence unless a contemporaneous objection was made, and the ruling affected a substantial right of the party. So I don't know what CE means here. Like, I'm assuming it means civil. No, I don't know. Louisiana something, Article 103A. I don't know what the CE means. I know like CCP is Civil Code Procedure. RS is Revised Statute. Don't know what the fuck CE is though. I could Google that. Oh, over here like, I'm looking this way because I've got the 2018 versions of like the Louisiana's Code of Procedure and shit like that. Like all of those big ass books, I got those over there. I got like 10 of them. They're heavy. I feel bad for law students. Man, your backs must be fucking breaking. But yeah, fucking, let's Google it. Nope. None of that helped me. Let's see. Welp. Yeah, I have no fucking clue. Google did not help me there. Anyway, okay. So according to some Louisiana civil law bullshit, I don't know, Article 103A, police first argued that appellant did not make a contemporaneous objection to the admittance of the deposition charge. What is it, charges of the deposition pages? What the fuck is wrong with me? I don't know. There are two rationales behind the contemporaneous objection rule. One, to put the trial judge on notice of the alleged irregularity so that he may cure the problem. And two, to prevent a defendant from gambling for a favorable verdict and then resorting to appeal on errors that might easily have been corrected by objection. And then it's citing some other legal bullshit here, fuck that. Further expressing this policy, Justice Weimer wrote in his Logan versus Schwab dissent, a party should not be entitled to stash an objection in his back pocket and sit on it, only to pull it out after an adverse judgment. And then it cites the legal bullshit there again. Appellant's statement of contested material facts states that appellant disputes any and all references to the depositions. See Louisiana Civil Code Procedure, Article 966 F2 through, and then I think it's saying through JB3 or some shit like that. I don't know. The transcript of the hearing on the motions for summary judgment reads, in relevant part, from Mr. Breeden, those depositions were not taken in this matter. And then there is an image here that we don't get to see. And then Mr. Breeden said, Your Honor, if you're going to consider these other depositions, then I at least will request that you, and the court said they were not objected to prior to this. Okay. I don't know who the fuck Mr. Breeden is. Anyway, although it appears that appellant's attorney may have been interrupted, oh, I guess that's the appellant's attorney, the transcript evidences, the fuck is wrong? Oh, I guess that's right. The transcript evidences that the district court knew that appellant objected. You fucking knew! Anyway, only native TikTok will understand. Actually, I think everybody gets that one now. But the appellant objected deep in the womb lands over here. Even if the district court did not believe the objection in the statement of contested material facts was sufficient, the district court was on notice of the alleged irregularity and had the opportunity to correct it. Thus, we consider whether or not the admission of the deposition parts was an error, and, if so, whether it affected appellant's substantial rights. Although Louisiana Civil Code Procedure, Article 966, B2, 2015, references depositions as possible summary judgment evidence, merely stapling documents to a motion for summary judgment does not magically transform them into competent summary judgment evidence. And some other legal bullshit is cited here. But it says Louisiana Civil Code Procedure Article 1450 states in relevant part, A, at the trial or upon the hearing of a motion or an interlocutory proceeding, any part or all of a deposition, so far as admissible under the Louisiana Code of Evidence. Oh, that must be what the CE means, Code of Evidence. Light bulb. Okay, under the Louisiana Code of Evidence applied, as though the witnesses were then present and testifying, may be used against any party who was present or represented at the taking of the deposition or who had reasonable notice thereof in accordance with any of the following provisions. Here it says emphasis added. I guess I don't know. I don't know the context of what they're adding emphasis to though, because I don't understand what the fuck is happening. But I don't know if that's like a them not communicating problem or if that's like a me not understanding problem. Anyway, so then it says, because no party asserts that appellant was present, represented at, or had notice of the depositions that made up the summary judgment motion. It says FI exhibit, but it's like the FI and exhibits are one word, and I've never fucking heard that before, so whatever. But it says it is unnecessary to analyze if any of the circumstances allowing for the admission of the depositions apply. The admission of these deposition parts was an error. As to the remaining question of whether admitting these deposition parts affected appellant's substantive rights, appellant was denied the right of cross-examination, the importance of which cannot be minimized in civil cases. And it cites some other legal bullshit here. And it says, as the Louisiana Supreme Court stated in Trasher, the thrust of Louisiana Civil Code Procedure, Article 1450, particularly paragraph A, seems to be that the party against whom a deposition is sought to be used must have been afforded a meaningful opportunity to cross-examine the deponent. And then it cites some utter bullshit here. It says, because appellant was deprived of this substantial right, the district court's admission of this evidence constitutes reversible error. Without the deposition testimony, there is not sufficient evidence before this court to show that the other party lacks factual support for their position. And it cites some legal bullshit here. And then it says, refusing to consider evidence that was not properly admitted on summary judgment when reviewing a grant of summary judgment and reversing the grant of summary judgment in relation to some other legal cases here that they are citing, which I don't understand. And then it says, accordingly, we reverse the district court's judgments granting the appellee's motions for summary judgment and remand the case for proceedings consistent with this opinion. We pretermit all of appellant's other assignments of error. Now we've got the decree. Every time I see this word, I'm over here like, hear ye, hear ye. Anyway, okay, so the district court September 29th, 2015 judgment granting summary judgment favor of URG. And I think those were the bitches that demolished the house, right? October 2nd, 2015 judgment granting summary judgment in favor of ASIC. I think those are part of the insurance company along with HCC. I don't fucking know. But look, the URG, ACIC, HCC, BBEC, these are all the fucking people that were either like the insurance people or the demolition people or the people involved in all of that had to do with the house getting demolished. So basically, the decree is saying that the summary judgments that were in favor of those people are reversed. Because previously they had used depositions from an entirely separate case as evidence. You know what I'm saying? And the court is basically saying, you can't just do that because she has to have the chance to be able to speak to her side of it as well, and it's one-sided that way, and the whole fucking point of a court procedure is for it to be two sides, right? So I think that's basically, in layman terms, what the fuck happened there. And then after that, it says reversed, remanded. The district court granted summary judgment in favor of Unified Recovery Group, URG, on September 29, 2015. In favor of AIG Specialty Insurance Company, ASIC, on October 2nd, 2015. In favor of Houston Casualty Company, HCC, on October 5th, 2015. In favor of Baroka and Banura, LLC, BBEC, on October 7th, 2015. And in favor of Scottsdale Insurance Company, Scottsdale, on November 20th, 2015. All of these judgments were substantially the same and referenced the motions for summary judgment filed by all of those bitches and as the motion granted. Okay. And so all of those people are the appellees. And yeah. And then it said, see 2015 Louisiana House Bill number 696. Louisiana 41st Regular Session, Section 2, stating, the provisions of this Act shall not apply to any motion for summary judgment pending adjudication or appeal on the effective date of this Act. And Section 3, stating, the provisions of this Act shall become effective on January 1st, 2016. Throughout this opinion, all references to the requirements of summary judgment motions reference the requirements of those motions prior to January 1st, 2016. We note that some of the motions were filed in 2014, rendering the 2014 requirements applicable, and some of the motions were filed in 2015, rendering the 2015 requirements applicable. The particular issues addressed in this opinion do not require an analysis of the changes to Louisiana Civil Code Procedure Article 966 between 2014 and 2015. Okay. So basically, from what I'm understanding, they're saying that some of the laws that apply to this case changed while this case was happening, and they don't feel the need to analyze the changes because they applied those changes as it was relevant to the proceedings for the year that the changes happened in, if I'm not mistaken. I think that's what they're saying here. But basically, from my understanding, so originally with this case, Lorene Randazzo basically had tried to sue all of these companies for demolishing her house after Katrina because it was condemned. And basically, initially, she lost her case. She was trying to sue them for damages, and she lost that case. But then she appealed it because when she lost the case, she didn't properly have the chance to speak or defend herself or to counter, what is the word, cross-examine the people that were having their evidence presented or whatever. You know what I mean? All that shit. And so they used some of those legal procedures to basically get that overturned. I don't know what that means for the damages. You know what I'm saying? Like, did those damages, does that mean she was then awarded damages? Also, if I'm not mistaken, I believe she may have passed away not too long after that. And so, if she was awarded those damages, you know, whether or not they got those damages could also be a different situation. I have no idea, you know, how that happened. But yeah. But what I do know is I do believe that case, for some reason, the fact that Mr. Salvador Randazzo's mother's house got torn down by St Bernard Parish, you know, even if it was condemned by Katrina, whether or not that was a valid condemnation, I don't know. Because on one hand, you know, yeah, like Katrina fucked a lot of houses up, and a lot of houses were fully condemned. There's no coming back from that. The best thing to do straight up is to demolish it and rebuild. It's just what it is. But on another level, I have worked on attorneys representing what's called the Road Home Program. And in the Road Home Program, what had happened was there was basically the state tried to use these grants called the Road Home Program to give a bunch of people money to come back and rebuild their houses after Katrina. So a bunch of the people that got those grants, the Road Home grants, then the government decided to sue those people afterwards, claiming that the houses should still be condemned for some cases and claiming that they didn't do enough to rebuild and shit like that, and so therefore they should get the money back. It was basically a money grab, in my opinion. Like, I'm sure there were some valid cases because, you know, there's always going to be some of that, but the amount of people they were going after who could prove that they really did rebuild and spend all of the money the way they were supposed to was just fucking ridiculous. You know what I'm saying? And one of the attorneys that I worked for, Sherman Khan, she actually got millions of dollars awarded from the state to her clients because they were trying to sue her clients, and they shouldn't have been trying to fucking sue her clients because they did what they were supposed to do. You know what I mean? So I do believe it is possible for that case to have gone either way. I don't know the details. It wouldn't surprise me if that house should have been condemned for sure, and it wouldn't surprise me if that house didn't need to be condemned, but the government was just trying to, like, do some land grab shit, you know, or make money a different way. You know what I mean? It wouldn't surprise me either way. So yeah. So, just to recap what we've looked at in this stream so far, we looked at kind of family history of the Randazzo King Cake family business. We looked at what they all have in common, and that common ancestor of the original Mr. Salvador Randazzo, the first one, where he opened the Highland Bakery in 1965. We looked at how all three of the Randazzo family members who are selling Randazzo family king cakes today, all of their websites discuss that family history. That is their root. That's what they all have in common. And then from there, we looked at another article that kind of explained the details of the family drama over the years, what has been made public. There was a physical altercation in 1994. There was also a lawsuit where the younger Salvador Randazzo, who was the attorney that got suspended, his father sued his own nephew
So, Mr. Lawrence Randazzo is Salvador Randazzo's father. Lawrence Randazzo sued Manny Jr. Randazzo. Wait, Manny Randazzo Jr. You know what the fuck I mean. So that's Lawrence's nephew. Manny is Lawrence's brother. You know what I'm saying? Like, so previously I had believed that the schism of this family was from the third generation potentially feeling untethered from the passing of the second generation. And not everybody in the second generation has passed, just a lot of people have. But now, after reading that article, I'm thinking that the schism started in the second generation, and this third generation is repeating the behavior and the patterns that they learned from that second generation. But yeah, and I'm also curious as to what those underlying causes were, and is it possible for that family to heal? And for me, so I come from 3 generations of truckers. My family has that family business, and my father tried to pass that on to my brother for the 4th generation, but my brother, you know, my family, on both sides of my family, they struggle with addiction. But my brother, hasn't been in the mental headspace able to, like, he has learned some from my dad, but he wasn't in a mental headspace to really carry that business with my dad. And my dad wanted to build a business together, and he wanted that to be a family business, you know. But yeah, so for me, it's like I've watched it in my own family, and I see the importance of it, and I really do hope that, you know, the whole Randazzo family can heal, can find ways to come to agreement, and to think of how are they going to keep their Randazzo corporation together for the future generations. So yeah. So next up, though, what I want to look at after this is the succession of Lawrence Randazzo. So previously we've looked at Mr. Salvador Randazzo's disputes with his cousins, and now I want to look at Mr. Salvador Randazzo's disputes with his siblings. And that, what is publicly available to us, is in the succession of his father, some of the legal documentation there. So what I'm going to do right now is take a little breaky break, and then we're going to come back. We're going to keep going through this next court document, and then I'm going to try and recap. And then if I cover this again, you know, I think next time what I'm going to try to do, if I can find it, next time I want to see if I can cover what was that physical altercation that occurred in 1994, and if I can find it. But since the lawsuit was dropped, there may not be anything much public record on it. But if there is any public record on the lawsuit that was dropped in 1994 between Mr. Lawrence Randazzo and Manny Randazzo Jr., then I want to cover that as well. But I'm definitely going to see if I can find any documentation on the physical altercation, and if I do find any documents on that, I'm going to cover that. But yeah, alright, so I'm going to take my break now. I'm about to roll my break thing, and then whenever we come back, I'm going to cover the succession, which is the inheritance paperwork. For those who don't know, the will is W-I-L-L. I accidentally said real because I have a real estate client, but I meant to say will estate. Will estate probate situation, that all has to do with inheritance, and that has to do with who is getting what when someone dies, right? And so I believe that there was additional altercation between Mr. Salvador Randazzo and his siblings. So yeah, so we're going to get into that. I'm repeating myself. I'm sorry. I'm out of it. Okay, I will be right back. Okay, so now let's just get right on up in here. We're gonna get into the succession of Lawrence J. Randazzo, and that would be Mr. Salvador Randazzo's dad. I think that this is the case where we see he was fighting with his siblings. So this is consolidated with the succession of Josephine Loyacana. I don't know how to say her name. Sorry. Then that would be Lawrence J. Randazzo's widow. And this was in the Court of Appeal, the Fourth Circuit as well. So it was an appeal from St Bernard 34th Judicial District Court. And it has Judge Joy Cossack Lobrano on it. Would be the one presiding over this, and Honorable Jerome J. Barbara III was the one who made the initial decision, if I'm not mistaken. Is Judge Joy Cossack Lobrano the person we just... Yeah. So this is the same judge from the Randazzo versus St Bernard Parish Government case. It's the same judge presiding over these cases. Okay. So... in this situation, the court was composed of Judge Joy Cossack Lobrano. Can we see? Can I make this bigger? I'm gonna make this bigger. That didn't work. Oh, that worked. Okie dokie. Whoops, wrong button. Sorry. Okay, so the court was composed of Judge Joy Cossack Lobrano, Judge Rosemary Ledette, Judge Rachel D. Johnson. Sorry if I'm saying people's names wrong. And so we've got Salvador J. Randazzo on behalf of Lorene A. Randazzo, and for appellants in proper person, we've got Jack E. Truitt, the Truitt Law Firm from Jack Truitt, Michelle May Davis, Kaylin K. Story, Luann Millman, all of that. Let's see. And then we've also got Cortez, Johnson, and Butcher, LLC, Jennifer Cortez Johnson, Nancy and Butcher over here. Let's see. And then for the counsel for appellee, Joel Randazzo Forget, and then that would be Patrina Randazzo Myers, 711 Kelly, all that. I'm not reading the address. That's my bad. And I'm just realizing that these addresses are in here. I'm kind of hoping that these are the office addresses. To be honest, I did not look into that at all. And I wish that the court would redact this shit before they publish it. Because why do we have to redact it? Like, why are you publishing people's public records? I don't know. So anyway, this was affirmed September 6, 2024. And so that would be last year at the time of this live stream. So Joel Randazzo Forget, if I'm not mistaken, is Salvador Randazzo's sister. So this is Salvador Randazzo. I honestly don't remember the difference. What's an appellant? Yeah, this is an appellee. So the appellate is the one appealing, and the appellee is the one to the higher court, and the appellee who is the one who won in the lower court and responding to the appeal. Okay, so the appellant, if the appellant is Mr. Salvador Randazzo, that means he lost, if I'm not mistaken, in the lower court regarding his sister, Joel Randazzo, if I'm not mistaken. Okay. So, case brief here. This is a succession proceeding. Appellants Salvador J. Randazzo and Lorene A. Randazzo appealed the June 12, 2023 judgment of the District Court, which ordered certain expenses of the successions be paid from the assets of the successions, sustained the motion to traverse the tableaus of distribution, I don't think I'm saying that right, and denied the other claimed expenses listed in the tableaus of distribution. Am I saying that right? I don't know. Of distribution or some shit. For the reasons that follow, we affirm the judgment of the district court. So, right here, they're saying they affirm the judgment of the district court. So basically, so Lorene, if I'm not mistaken, has passed away at this point. So Salvador is putting Lorene in there in the legal documentation, I believe, because he was listed as the executor of her will originally. But I believe, if I'm not mistaken, his siblings were not happy with how he was spending the money from the estate. And so, if I'm not mistaken, they went to the court to basically ask the court to allow them to have input on that, if I'm not mistaken, or some shit like that, you know, to reduce his legal authority over the estate, or at least make it so he had to do certain things with the money. And he tried to, so they won that, if I'm not mistaken, and he tried to overturn it. And he lost that, and so it went in their favor, if I'm not mistaken. So yeah, so from this situation, we can see, as of 2024 or 2023, it doesn't look like Mr. Salvador Randazzo had the best relationship with his siblings as well as with his cousins. On top of the fact that now he is disbarred from being an attorney. And so, you know, without knowing this guy, like, so Mr. Salvador Randazzo, he could be just like a complete asshole, greedy piece of shit, or he could just be like a lost soul right now. You know, I don't know this dude at all, so I'm not trying to project any shit on him. But I feel for either way, regardless of the situation. You know, you can kind of feel for the guy, like, because right now, you know, well, he's definitely going through something, you know what I mean? To be putting yourself in a situation, like, I don't feel like you mentally get to where you are risking your license as an attorney and jeopardizing your career, and you get to the point where you are destroying your relationships with your family, you know, without there being some sort of underlying root issue that needs to be addressed. And on surface level, yeah, it does just kind of come off. If you look at this superficially, you could just easily say he's just greedy, he just wants more money and all of that. But at the end of the day, I think it comes from, when you look at the family history, it comes from a history of learned behaviors and reactions. And I think it does come from grief and trauma and no longer having the family connections. I really do believe that, you know, the family business being built on the family, when it made it, by the time it made it to the third generation, when the first and the second generation, those two generations were passing on, then the second and the third generation didn't have that commonality to keep them together, because they're all just trying to get by in their own way. But because, like, you know what I'm saying, like, where, for example, in 1994, Mr. Lawrence tried to sue Mr. Manny Jr. for saying that it was his fault he didn't make $100,000 or some shit. And on surface level, that just looks really greedy. But when you look into it more, like, that he's probably struggling as a business owner for different reasons, and projected his insecurities onto his family. You know what I'm saying? Like, it doesn't make it right, but I feel like there's just more to it. Like, it's very superficial is what we're getting. I don't know. So yeah, okay, let's actually get into the facts and procedural history now. So, this appeal arises from a dispute over reimbursement of expenses allegedly incurred by Salvador J. Randazzo, who is the former executor of his parents' consolidated successions. Appellant's other two siblings, appellees Joel and Randazzo Forget, what am I saying, Joel Randazzo Forget and Patrina Randazzo Myers, siblings, opposed court approval and payment of certain alleged expenses. Let's read the footnotes. Footnote 1. Salvador J. Randazzo is an attorney, but he and Lorene A. Randazzo both appear in proper person. Oh, so at this point, Lorene has not passed.
Apologies. I don't know why I thought she had. Oh, Josephine is the mother, not Lorene. I apologize. Actually, I think Lorene might be a sibling. I can't remember. Anyway. Okay, so we refer to them collectively as appellants. In quotations from the lower court's reasons for judgment, Salvador J. Randazzo is sometimes referred to as the executor. As discussed herein, he was removed as executor on February 6, 2023, and our court's record does not show that another executor was appointed. For consistency, we refer to Salvador J. Randazzo as I cannot speak. Executor. Is it executor? No, I don't know. Whatever, fuck it. Executor throughout the opinion. Okay. In our opinion, we refer to the decedent Lawrence J. Randazzo as father and the decedent Josephine L. Randazzo as mother. I mean, is that an opinion or is that a fact? Anyway, okay, so those are the footnotes. Continuing. The district court set forth the following factual background of this matter and its reasons for judgment, listed with the judgment presently on appeal. Lawrence J. Randazzo died on March 3, 1998. His succession was opened with a filing on April 9, 1999, including a petition to probate his last will and testament, and the appointment of Salvador J. Randazzo, his son, and heir as executor without bond or other security. Josephine L. Randazzo, wife of Lawrence J. Randazzo, died on April 3, 2008. Her succession was opened with a filing on October 24, 2008, including a petition to probate her last will and testament and the appointment of Salvador J. Randazzo, her son and heir, as executor without bond or other security. The executor, Salvador J. Randazzo, is one of 4 children of the descendants. The others are Lorene Randazzo, Patrina Randazzo Myers, and Joel Randazzo Forget. In 2011, over 13 years after their father died, and over 3 years after their mother died, sisters Patrina and Joel retained an attorney and filed a petition to remove their brother as executor, claiming that he had not filed an annual accounting for either succession despite the many years that had passed since their parents died. Accountings were prepared by the executor in 2011. Why am I saying 2011? I think because I just said it. In 2022, damn it, and provided to other parties, but the record does not reflect their filing with the clerk. They also complained that he had not responded to discovery requests from their attorney. I'm going to read this footnote real quick. Appellants designated the record on appeal, and only some of the pleadings discussed in this procedural recitation appear in this court's record. We also recognize, as courts have long held, that the appeal is taken from the judgment, not the written reasons for judgment. Some legal shit is cited here. Nevertheless, the appellate court may review the reasons for judgment to the extent they provide elucidation for the lower court's ruling and to determine whether the judgment contains legal error. Some other legal shit cited here. Back to the case. The case finally went to trial in 2014, and while the motion to remove him was denied, the court appointed his sister, Patrina, as co-executor, and the executor was ordered to file annual reports for the years after his mother's death in 2008. He was also ordered to answer the discovery. A motion for a new trial by the executor was granted, setting aside the results of the hearing. The district court judge, sitting ad hoc, was appointed to preside ad hoc in this matter in July 2021. After a conference in August 2021 between the court, the executor and his sisters, Patrina and Joel, attorney, the executor was ordered to provide counsel with drafts of detailed descriptive lists in both successions within 30 days. Drafts were provided, but the list were not filed into the record until July 5th, 2022. The executor has never, by his own account in conference and in pleadings, opened a succession bank account in either proceeding, but instead he directed the entities that the descendants had co-ownership interests in to pay the heirs in equal shares when funds were dispersed. So instead of making one account, apparently they all should have gotten their money at this point, if I'm not mistaken, for what they were individually owed. But I'm wondering if what they are fighting over is other assets that may have been collectively given to them, perhaps? I'm not sure. Because right here, I'm like, in my head, I'm kind of like, well, why would they be fighting over how the assets were spent if they each got their own fucking money? You know what I mean? But, so I'm assuming we'll get to that. Okay. And then it says, the executor engaged in litigation in 2012 and 2015 with St Bernard Parish Government over issues involving succession property damaged by Katrina, which involved issues about whether the property was being maintained properly. A second motion to remove the executor was filed by sisters Katrina and Joel in November 2016, prompted by new citations by St Bernard Parish Government over the condition of the succession property in St Bernard. The property has since been demolished, as testified to by the representative of Parish Government at the trial of this motion to traverse. The executor filed suit in 2015 in St Bernard Parish on behalf of the successions against other family members who are co-owners of alleged succession property, alleging that they are not properly accounting for and distributing income from the jointly owned property. Okay, so that is what it is. That matter is still pending, with a motion to recuse the presiding judge filed by the executor. And I believe that was part of his suspension that we covered, if I'm not mistaken. Anyway, it says the motion to recuse was denied on January 19th, 2022, after hearing. And in the reasons for judgment, the ad hoc judge referred to the history of that case and other litigation, as described in the executor's motion to recuse, as tortured and combative. But you know, I find it entertaining that Mr. Salvador Randazzo called everybody else, like, was kind of accusing everybody else of being torturing and combative. But when you look at the fact that it's kind of him against his entire family, then it kind of seems like it's like pot calling the kettle black now, isn't it? You know what I'm saying? Like, I don't know, because he's the one that's fighting with going against his entire family. So isn't he the one being combative and torturing them, huh? I don't know. But maybe there's more to it than that, because I feel like in some situations, when you've got everybody against you and you're the only one sticking, like, trying to go a certain way, it can be because you're in the wrong. Sometimes it's like, you know you're wrong, that's why everybody's against you. And then in other cases, and this is just speculation, because I have no background on any of this shit. I don't know what the fuck happened. It's not even speculation. It's just more of like a different conversation triggered by this one. So in other situations, though, you could have it where it's like sometimes the black sheep of the family is the only one speaking up against corrupt bullshit. You know what I'm saying? Sometimes the black sheep of the family is the one who's actually speaking out about abuse in the family, and that's why everybody is shunning the person speaking out about the abuse, because they want to keep covering up the abuse and maintain the status quo. So you see it both ways. Sometimes when people are the only ones speaking out, sometimes that is, like, when you look at the situation, it is because they're the problem, and sometimes it's because the group is the problem and they're the only one trying to do anything about it. So, you know, I don't know what the case is with them, but I just think that on a superficial level, without knowing shit about them, when Mr. Salvador Randazzo is claiming that his whole family is torturing him, but he's the one filing paperwork on his entire family to prevent them from doing what they want to do with their assets, it kind of looks like it's the opposite way, right? But maybe I'm wrong. I don't know shit about what happened. There could be way more to it, you know what I mean? But yeah. Anyway, next up, it says emphasis omitted here. I don't know what the fuck they were emphasizing to omit, but whatever. Anyway, then it says, subsequently, the 2014 motion to remove the executor filed by Siblings, for which a new trial was granted, proceeded to trial on February 2nd, 2023. All 4 heirs appeared at trial. On February 6, 2023, the district court granted the motion and ordered Salvador J. Randazzo removed as executor. No appeal was taken from that judgment. While the motion to remove the executor was pending, Executor retained an attorney, now discharged, who prepared a tableau of distribution for each of the successions. What am I saying October? The fuck? On August 31st, 2022, Executor sent notice of the petition for filing the tableau of distribution for each of the successions. On September 12, 2022, Siblings filed a motion to traverse and objections to both tableaus of distribution. On September 20th, 2022, Executor filed in the district court both petitions for filing the tableaus of distribution. In the tableau for father's succession, Executor sought reimbursement for alleged debts and succession expenses in the sum of $140,708.82. In the tableau for mother's succession, Executor sought reimbursement for alleged debts and succession expenses in the sum of $332,314.91. So basically, he's trying to get reimbursed like $500,000, if I'm not mistaken. But what I don't understand is if all the money was distributed to each person into their own accounts, and if what they're arguing over is separate community property between their family, what the fuck does he have to be reimbursed for? Like, is he trying to make them reimburse him for the legal fees that he decided to spend on him suing them, or trying to stop them from taking legal action with the business dealings they wanted to do? Like, this part I do not understand. What the fuck? You know what I mean? But maybe it'll explain more. But anyway, so it says the motion to traverse proceeded to hearing on April 18, 2023. Siblings appeared for the hearing. Appellants were served with the notice of hearing, did not appear, and were not represented by counsel at the hearing. On June 12, 2023, the district court rendered judgment as follows. Ooh, now we're getting to the judgment part. It is ordered, adjudged, and decreed that the following sums, identified as legitimate expenses of the successions named above and listed in the tableaus of distribution, are hereby, homologated. And then, what the fuck does this even mean? Hold on, I am so distracted. The fuck does this mean? How do I say you?
Homologate.
Homologate, okay. That means approved. Alright, anyway. Are hereby homologated, and these sums are, therefore, properly payable to the creditor listed in the tableaus from the assets of the successions, except to the extent they have already been reimbursed. So, unless they've already been reimbursed, then from their shared assets, he can take this money, is what I think they mean, if I'm not mistaken. So, from the succession of father, we have A, funeral expenses, $9,134.37, appraisal fee, $2,600, clerk of court costs, $900. From the succession of mother, Funeral expenses, $11,180. The fuck you mean grass cutting and maintenance was $25,228.50? What the fuck? Hold on. Who the fuck is cutting your grass? How much grass did you have that needed to be cut? What? And if it was demolished, like, what maintenance was done? You spent money to be maintained and then it got demolished? Like, I don't know. This part is throwing me for a loop. Taxes on, dude, I don't even know what the fuck this is. What the fuck is this? Leave it, shit. Hold on. I'm too poor for this. Apparently it's a New Orleans Police Department guy. Taxes on... I'm assuming it has to do with the law. Right here, there was a law firm listed... Oh, no. Never mind. Maybe it has to... Oh, I just clicked away. Maybe it has to do with the law firm? Taxes on the law firm? I have no clue. I'm too poor and too ignorant to know what the fuck they mean by that. But taxes on this Livicari, I don't know how to fuck to pronounce that, $7,302.38. I guess it's a property because right here it says taxes on Urquhart property, $3,213.40. So if it was a property, then that would make sense to me. But otherwise, I don't know what the fuck it means. Okay, and then it says, it is further ordered, a judge and decree, that all of the other expenses, claims, and charges listed in the tableaus of distribution filed in these proceedings are denied. Sustaining the motion of traversals to those items, and those items shall not be paid or reimbursed from assets of these successions. Aha, okay, so he had asked for like $500,000. And I had said when he asked for that, like, what the fuck? How the fuck are you gonna ask for $500,000? And the judge was like, no, we're not gonna give you $500,000. No. But you can have whatever the fuck this amounts to. I don't know. What is this, like 50,000? So yeah. Anyway. I think this is like 60,000 actually. This is this is somewhere between 50 and 100,000 they said he could have. But he had asked for like 500,000. Like, god damn, that's a lot of money. Anyway, it also says it is further ordered, a judge and decree that all costs of these proceedings are assessed to Salvador J. Randazzo. This appeal follows. Okay, so you know what though? I've been wondering what the fuck is Mr. Randazzo gonna do now that he can't be an attorney for the next few years. But to be honest, depending on what his finances are, if he doesn't have to pay for like a house, you know, if he's got his house paid off, if he's got his car paid off, then he could probably live off of this for a second until he can be an attorney again, if he doesn't have other funds. You know what I mean? Anyway, so moving on. Law and analysis. The fun part, actually this is the boring shit. Appellants assert that the lower court committed legal error in two respects. First, in failing to homologate, grant court approval to pay various expenses listed in the tableaus of distribution. And second, in taxing all costs against executor. Traversal of tableaus of distribution. Legal principles and standard of review. As a general matter, the appellate standard of review of factual findings is whether the lower court was manifestly erroneous or clearly wrong. And citing some legal bullshit here. By the same token, appellate review of a district court's judgment homologating the tableau of distribution or refusing to grant an order doing so is subject to the manifest error standard, and the judgment must be affirmed if the record as a whole reveals that there is a reasonable factual basis for the decision. Some other legal bullshit decided here. Legal error occurs when a lower court applies incorrect principles of law, and such error is prejudicial. Legal error is prejudicial when it materially affects the outcome and deprives a party of substantial rights. Some other legal bullshit is cited. where a legal error interdicts, I can't speak, when legal error interdicts the fact-finding process. Is that how you say this? Is it interdicts? I don't know, man. Either way, I'm not mature enough for this pronunciation. When a legal error does some shit with the fact-finding process, the manifest error standard no longer applies. Okay, what the fuck does this word mean? Hold on, I'm sorry. I'm ignorant. An authoritative prohibition.
Interdict.
Oh, it is interdict. Okay. Dicking around over here. And if the record is otherwise complete, the appellate court should make its own independent de novo review of the record and determine a preponderance of the evidence. Some shit is cited. Appellant's primary complaint is that the district court erroneously failed to reimburse Executor for certain claimed expenses from the succession funds. Executor raised his claims for reimbursement by filing petitions to homologate the tableau of distribution in each of his parents' successions. Siblings opposed the petition by filing a motion to traverse the tableaus of distribution. Review of these claims warrants the following discussion of the pertinent succession procedure. Speaking of family business, my twin used to own Monkey on Carrollton and Cleveland. And she's opening up a new coffee shop. It's currently going to be off of Canal. She's currently doing coffee by appointments only. So if you miss your Monkey coffee and you want coffee like that, and you want to get my twin's coffee recipes and her chocolate chip cookies. Oh, I want a fucking chocolate chip cookie from Tori right now. Okay, my twin has the best chocolate chip cookies you will ever eat. Anyway, I want one. So she's opening up a new coffee shop. I forget the name of it or whatever. Dude, I'm a terrible twin. But it's in, they spell it with a K. They call it Nola Castle. Knowla Kastle on Canal or whatever. And then I forgot what the fuck they're calling the coffee shop inside there. But it's not properly technically open because they're still doing construction and getting all of this shit in order. So it's going to be officially open as soon as that is done. Whatever fucking timeline that takes, we don't know. We're hoping it's done by next year. But for now, she is allowed to take appointments and do individual coffee appointments. She just can't do, she just can't have people stay in the building because it's not safe for you to stay in the building. But she does have a shop area where it is safe for you to go to, and you can go get your coffee if you'd like. Sorry about that. Anyway, so let's actually read this thing. The tableau of distribution is a document listing estate debts that are to be paid from available succession funds. See Louisiana Civil Code Procedure, Article 3303. The function of the tableau of distribution is to notify creditors and other parties interested in the succession that the succession representative proposes to pay the listed estate debts and obtain court approval to make said payments. Estate debts are debts of the decedent and administration expenses. Louisiana Civil Code, Article 1415. Debts of the decedent are obligations the decedent incurred during his lifetime or those that arise as a result of his death, such as the cost of his funeral and burial. That is, administration expenses are obligations incurred in the collection, preservation, management, and distribution of the estate of the decedent, which encompass preserving, safeguarding, and operating the property of the estate, such as repairs, cost of maintenance and upkeep, interest attributable to a debt, and custodial fees. And then it cites Louisiana Civil Code or something like that, I think. I don't know. Article 1415, 1997 revision comments or something like that. I don't know. Ordinarily, a succession representative may pay an estate debt only with the authorization of the court. Louisiana Civil Code Procedure, Article 3301. When a succession representative desires to pay estate debts, he shall file a petition for authority and shall include in or annex to the petition a tableau of distribution listing those estate debts to be paid. Louisiana Civil Code Procedure, Article 3303A. I'm going to read the footnotes. Succession representative includes an administrator, provisional administrator, administrator of a vacant succession, executor, and dative testamentary executor. I don't even know what the fuck all that means. It's from Louisiana Civil Code Procedure, Article 2826, Section 3 or something. I don't know. Item 3. And then here we go. We got Louisiana Civil Code Procedure, Articles 3304 through 3306 govern this notice requirement for the petition for authority to pay estate debts, which are not an issue in this appeal. Okay, back to the case. An opposition may be filed at any time before the tableau is homologated, and the opposition shall be tried as a summary proceeding. Louisiana Civil Code Procedure, Article 3307A. Presumption of validity of claims. The crux of appellant's argument is the presumption of validity afforded to claims listed in a tableau of distribution. Pursuant to Louisiana Civil Code Procedure, Article 3244, the inclusion of the claim of a creditor of the succession in the succession representative's petition for authority to pay debts, or in his tableau of distribution, creates a prima facie presumption of the validity of the claim, and the burden of proving the invalidity thereof shall be upon the person opposing it. According to appellant's argument, executor is a creditor of this succession. In his capacity as executor, he listed his own claims, which are presumed valid, and siblings failed to meet their burden to rebut those claims. Few cases illustrate with specificity how the presumption applies, and we provide a brief recitation of their facts here. And some other fucking case shit they're citing. It says this court recognized both the Article 3244 presumption and the lower court's discretion to reject reimbursement of legal expenses wherein the court was unable to determine which items relate to services rendered, and the attorney's capacity representing the sole heir individually, for which she would be obligated personally, or which items are legitimate charges against the succession. It says, see also another fucking case they're citing here, and recognizing the long-standing principle that where the legal representation is primarily for the personal benefit of the executor and not the estate, such fees may not be paid from the property of the succession. That's what I'm talking about. And then it said, the Meyer court noted, I think that's referring to one of those cases that they were just saying, there is not one word of testimony in the transcript nor any documentary evidence offered to verify the items listed. The trial judge rejected them, and we find no error in his judgment on the face of the record before us. Then it's citing some shit here. It says this court further explained that the Article 3244 presumption does not prevent a lower court from rejecting claims, particularly where a succession representative can prove disputed expenses and fails to come forward with such proof. In the absence of opposition, the succession representative is not required to verify or prove every item in the manner required when an item is in dispute. In this case, no opposition to the administrator's account and tableau of distribution was filed, and the only objection, as we have pointed out above, was raised by the court. The administrator and his attorney, however, cannot assert that they have been denied an opportunity to make the required proof of the contested items. They were well aware of the court's opposition to the items totaling $931.68, since the court had twice previously rejected this claim. If they had proof sufficient to overcome the court's objection, it should have been submitted. Yeah. And then it says, in another fucking case or something that they're citing, this court found no manifest error in the district court's factual findings that attorney's fees were reasonable and the services benefited the succession. On an heir's opposition to the homologation of the tableau of distribution, the lower court received conflicting evidence and testimony from the opposing heir, the executor, and the attorneys regarding the purpose of fees and particular actions undertaken to avoid litigation and minimize tax liability. Some other shit is cited here. On review of the appellate record, this court concluded that a reasonable factual basis existed for the district court's determination that the heir had failed to meet her burden to rebut the Article 3244 presumption of the attorney's fee validity. And some shit is cited here. In succession of Lorene, I guess it's another fucking case, and then they're citing a bunch of shit here I don't understand. This court increased the attorney's fees and executor fees awarded in the judgment homologating the tableau. The record on appeal lacked any explanation of the lower court's reasoning for awarding an amount lower than listed in the tableau. Recognizing the Article 3244 presumption and the reasonableness of the work performed, this court found the district court abused its discretion in reducing the fees from those amounts specified in the tableau and supported by itemized lists detailing the number of hours and type of work performed by them in defending the testament from attack. Some legal bullshit is cited here, and in another legal bullshit case thing that they're citing, the executrix sought to traverse her own tableau of distribution, which she had filed 5 years earlier. The executrix, that sounds like the Matrix, sought to challenge attorney's fees that she had included in the tableau, and which she had paid at the time without opposition. On appeal, the reviewing court determined that the district court had properly placed the burden of proof on the executrix as the party opposing the attorney's fees, as provided in Louisiana Civil Code Procedure, Article 3244, or some shit like that. I don't know. In another case, in succession of Martin and some shit cited here, opponents of the tableau of distribution filed an opposition but offered no evidence to substantiate their opposition. They testified only that they did not have any particular reason for opposition other than they felt the claim was unsupported. The lower court overruled the opposition, which the appellate court affirmed, holding that under Article 3244, the mere filing of an opposition to the payment of a debt included in the succession representative's petition for authority to pay debts does not rebut the presumption of validity nor meet the burden of proving invalidity thereof. Summarizing these cases, Louisiana courts viewed the Article 3244 presumption as rebuttable, not conclusive. Where an opponent introduced contradicting evidence, or where a lower court discerned that an executor could have come forward with supporting proof of a disputed expense and did not do so, the lower court's discretion in rejecting the claim or declining to homologate the tableau has been upheld on appeal. Okay, executors' reimbursement claims. In the matter sub judice, appellants complain that executor should have been reimbursed for the following: all attorney's fees and court costs, Hibernia National Bank loan representing an amount executor loaned mother through a limited liability company to purchase another home after Hurricane Katrina, the Jade Court property, maintenance, supply, and repair costs, and multiple cleanings for the succession property in St Bernard Parish, which was damaged in Hurricane Katrina, And that's, okay, the Livachari, whatever the fuck, drive property. So it was a property. All right. Property taxes for the Jade Court property. Various property taxes in St Bernard Parish. Expenses to Delta Fence for the Jade Court property. And federal and state income taxes on behalf of Mother. Okay. Siblings argue that they properly opposed the tableau, and when appellants failed to appear at the hearing, appellants failed to overcome siblings' objections. According to siblings, the district court acted correctly and within its discretion when it sustained the objections and disallowed disputed and unsupported expenses. Siblings further argued that Executor's claims against the successions were not properly documented in annual accountings or sworn detailed descriptive lists and are now prescribed or barred under the Dead Man Statute. Louisiana Revised Statute, some bullshit, 133721, they contend that the claims for home repairs, renovations, property taxes, and income taxes while the parties' parents were living are improper claims. I'm going to come back to the rest of this. I'm going to read the footnotes real quick. So basically, they're trying to claim that all of this shit wasn't valid. I don't know. On face value, that does seem like valid expenses, but we don't know more to it. Perhaps the amount could have been exacerbated or something that we don't know. But yeah, like, I feel like this case could have gone one or two ways. Either Mr. Salvador Randazzo is trying to be responsible with the money and the siblings are opposing it because they want to spend the money on other shit. But if it was that way, then why would the court rule in the favor of the siblings, right? Or, you know, Mr. Salvador Randazzo may not have been 100% upfront about where some of the money was going, and that's why the siblings had to step in. Or maybe he was upfront about where the money was going, but there was still a disagreement about it, you know? But either way. Anyway, so for the footnotes here, it says prescription was not specifically pled in an exception below and was not addressed by the trial court. According to the reasons for judgment, it was mentioned for the first time in appellee's post-trial memorandum, and the district court did not address it or rule on it. We lack authority to address it for the first time on appeal on our own motion in the absence of an exception of prescription. So prescription, if I'm not mistaken, in Louisiana law is basically like isn't it like the kind of like the statute? Hold on. If I'm not mistaken, prescription, this is not properly explaining it to me, but if I'm not mistaken, I believe the period of prescription is basically like your statute of limitations, if I'm not mistaken. It's like the time period you have to do some shit, if I'm not mistaken. But I could be wrong. Google did not help me just now. I don't know. I could have looked more into it, but I'm not doing it. I just don't feel like I'll just focus, you know. So back to this. The next footnote, it says, under the Louisiana Revised Statute 133721 or whatever, parole evidence shall not be received to prove any debt or liability of a deceased person against his succession representative, heirs, or legatees when no suit to enforce it has been brought against the deceased prior to his death, unless within 1 year of the death of the deceased, the claimant takes certain actions enumerated in the statute. The purpose of the Dead Man Statute is to protect the estate of decedents, their representatives, and heirs against stale and unfounded claims which might have been refuted or disproved by the testimony of the deceased were he living. Okay, so here we go. Now I see. So Mr. Salvador Randazzo was claiming that he had been paying for the estate of certain issues as it related to his parents' housing and things of that nature. And where the siblings were able to successfully apply the Dead Man Statute on that, that could have been because it was up for debate about how much involvement Mr. Salvador Randazzo had with the ownership of those properties, if I'm not mistaken, potentially. Perhaps that is it. But I could be wrong. I'm just like trying to process, which means I'm basically bullshitting here. Okay, so next up, back to the case. It had said they relate, and it's talking to the siblings opposing the Mr. Salvador Randazzo right now. They further oppose expenses related to the Livachari, I can't say that, my bad. Related to a property which Executor failed to maintain after that property was damaged in Hurricane Katrina and was thereafter neglected, fell into further disrepair and blight, and ultimately was demolished by order of St Bernard Parish Government. So it's that case that we just read before the break. So yeah, and then it says, our review of the expenses disputed on appeal reveals the following. Both tableaus list attorney's fees and court costs, which are undated and fail to specify what legal service was provided or what court cost was incurred. In both tableaus, certain legal fees were demarcated as estimated. It has long been recognized in Louisiana law that an executor of a succession may obtain an attorney to aid in the carrying out of the executor's duties and to defend the succession against adverse claims made against it. I'm sorry, hiccuping and burping over here. Some other legal shit is cited here, and it says, this court has held that fees for legal representation may be charged to the succession where such representation is for the benefit of the estate rather than for the personal benefit of the executor. This court has characterized a list of legal fees with undocumented monthly amounts for various years as uncorroborated and unsubstantiated. Some other legal bullshit is cited here, and then it says, as we explain, the reasonableness of an attorney fee award is always subject to court scrutiny. The succession representative who seeks court approval to pay such fees must, however, meet a threshold burden of establishing the basis and amount of the fees, just as she would be required to do to obtain court approval to pay other debts or charges of the succession. And some legal shit is cited here. Executor's sister, appellee Joel Forget, testified that Executor had not provided her with any documentation of particular legal expenses or costs, despite her repeated requests. The district court's judgment homologated payment of $900 in clerk of court costs, which, according to the reasons for judgment, is the amount to which siblings conceded they do not object. As to the claimed loan to mother, arguments in appellant's brief are inconsistent with the claims listed in the tableaus. The brief references a Hibernia National Bank loan of $191,465.08, while also arguing that is the loan from executor to mother for the purchase of the Jade Court property. Both tableaus, however, identified an undated Jade Court cashier's check from Hibernia National Bank in the amount of $465.08. The tableau for mother's estate separately lists a real estate loan in the amount of $135,000 made to 321 Jade LLC. No documentation or evidence of either alleged loan is contained within this court's record. Joel Forget testified that the Jade Court property was paid for with insurance proceeds from the Livachari shit, man, I don't know, from that word I can't pronounce, from a property, whatever, damage claim, and that the executor contributed additional funds with the expectation that he would live in the Jade Court property. Okay. So at this point, though, if the Jade Court property was community property for those siblings, then the executor of the will can't just expect to live there without approval from the siblings, right? That has to be a joint decision. But if that property was supposed to be for him, then I can understand why the fuck he thought he was going to live there. You know what I mean? When it comes to the loan situation, I do feel for him because I do believe perhaps it is possible he had an agreement with his mother for, the financial situation. But at the end of the day, if it's not in writing, then you can't. Then I can also understand why on the sibling side, if they had nothing to do with that and they have nothing in writing to verify or back that up, and they're also arguing over all of these other legal issues related to the money because they're questioning where the money is going, I can understand why they're questioning the loan. So I can see both ways. I don't know, I'm like overstimulated with my hair today. Whatever, fuck it. Like I keep putting it up and then taking it down because I just feel weird. Okay, let's keep going. So it says regarding maintenance and repairs of the shit. Can someone tell me? I'm gonna Google this. How the fuck do I say you? Sorry. Oh shit, that didn't work out. Yeah, how to Livacary. Oh shit, man, I've been saying that way wrong. I don't fucking know. Livacary. Okay. Anyway, so regarding maintenance and repairs of the Livacary Drive property, both tableaus contain numerous undated entries regarding Livacary, containing no description of the service provided or purpose of the expense. Joel Forget testified to her understanding that mother had usufruct over the property in father's estate and lived in the Livacary Drive property along with Executor until Hurricane Katrina in 2005. So if he lived there before, I guess I could see why he would plan on living there again or want to live there again. You know what I mean? If I'm not mistaken, I believe usufruct is like whenever somebody owned a property and then you're like their survivor or whatever, their beneficiary legally of their inheritance, and you take possession of it. I think that's what the usufruct thing is. I don't even think I'm saying that right. But you know what? Let's just Google that just to be sure because I don't even know if I explained that right. I don't know if that's right. Hold up. The fuck is a usufruct? Yeah, that basically is what the fuck it is. Anyway, so, and then it says, as siblings pointed out, the Livacary Drive property was damaged in Hurricane Katrina. Therefore, Executor failed to repair or maintain the property to the point where St Bernard Parish imposed numerous building ordinance violations against the property relative to dangerous structures and sanitation. As testified to by Clay Dillon, Chief Compliance Inspector for the St Bernard Parish Government, the parish ordered the Livacary Drive property's demolition, which was accomplished in March 2023. I thought it happened, or is that a different property? I don't know. You know what? I'm getting shit confused. Anyway, at a cost of $14,200. Siblings conceded to a total of $25,228.50 in grass cutting and maintenance expenses for the succession properties. Oh, okay. So they conceded to that. That's a lot of money. Goddamn. Executor claims he is due $1,838.50 in reimbursement for undated expenses to Delta Fence for the Jade Court property. As to property taxes, Executor claimed reimbursement of $68,127.86 in property taxes for the Jade Court property. Joel Forget testified that both appellants have lived in the Jade Court property since its purchase. So they've all been up in there. And the district court recognized the need to reserve this issue for future separate trial to determine any applicable offset relative to co-owner status. Yeah, because at that point, I feel like, yeah, it's equally kind of all theirs, in my opinion. Executor complains about an additional $1,628.57 in various property taxes paid to Sheriff Jack A. Stevens, seemingly associated with St. Bernard Parish properties. Joel Forget testified that she paid the 2021 property taxes for the Jade Court property and the 2022 taxes were unpaid. She further stated that she redeemed the property for unpaid taxes for the years 2015, 2016, and 2017, and Patrina Myers reimbursed her for approximately $16,000. Joel Forget also testified that Patrina Myers paid unpaid property taxes for the St Bernard Parish properties. Siblings conceded to claims of property taxes in the amount of $7,302.38 on the Livacary Drive property and $3,213.40 on the Urquhart property. Appellants also argued their entitlement to reimbursement of $11,842 in income taxes paid. In the Tableaus, Executor claims to have paid income taxes on both parents' behalf in 1995 and 1996, and on mother's behalf between 2001 and 2004. We find little guidance in appellant's argument concerning succession of another fucking case, wherein a provisional accounting was filed showing that attorneys for an executor advanced money for installments of income tax. We see no support in the law for construing income taxes during the descendants' lifetimes as estate debts. Joel Forget testified that both parents had sufficient funds to satisfy such payments, not only from Social Security income, but also through the interest in Randazzo properties and TOCA lease payments they received. She also explained in her testimony her doubts on the whole that outstanding loans existed between the executor and mother, or that there was any expectation of repayment, because mother never left anything outstanding with any of us. Basically, the siblings are saying, the fuck is he saying that he paid for our mother's shit for when our family and our parents are the reason we have money? You know what I'm saying? So they didn't need him, we needed them, is what the siblings are saying, in my opinion. You know what I'm saying? That's why, that makes sense to me. Anyway, I'm just roughly summarizing, paraphrasing, not wording things correctly. I'm not trying to put words in anybody's mouth. I'm just trying to process. But anyway, okay. So then it says, we acknowledge as a general matter that Article 3244 imposes a presumption of validity on claims listed in the Tableau of distribution. Even so, this circuit has long This circuit has long recognized lower courts' authority to decline payment of disputed claims, which are within the executor's power to substantiate, where he has failed to come forward with supporting proof. And it cites a fucking case here. And it says, moreover, this court explicitly held that allegations contained within a tableau of distribution are not evidence. And something else is cited here. And then it says in something here, the record on appeal contained the co-executor's allegations of debts and the opposing heir's objections, but contained neither a transcript of the proceedings nor any evidence supporting the co-executor's claims that the disputed debts existed or were owed by the succession. In such a posture, this court found no abuse of discretion or manifest error in refusing to homologate the tableau. Analogous circumstances are present here. Siblings opposed the tableaus of distribution through their motion to traverse. Executor was ordered removed as succession representative, which judgment he did not appeal. Executor did not appear for the hearing on the motion to traverse, did not testify, and did not offer any evidence supporting that the disputed debts existed or were owed by the succession. Siblings appeared and testified about their objections to the claimed debts, though evidently they conceded to some of the expenses, which were the same expenses the district court ordered homologated. Furthermore, appellants opted to designate the record on appeal, as a result of which a complete record of the proceedings below is not before this court. Louisiana Civil Code Procedure, Article 2128, permits an appellant to designate the record and limit it to such portions that he desires to constitute the record on appeal. However, the inadequacy of the record, if any, is imputable to the appellant, and some legal shit is cited here. The reviewing court must presume that the trial court judgment is correct and supported by sufficient competent evidence when a designated record is inadequate for a review of the matter at issue. To the extent that there is anything missing from the record of the proceedings below that would support appellant's claim on appeal, appellants have made no efforts to correct the deficiency or ensure that a complete record is before this court. The district court's reasons for judgment make plain that it approved only the expenses to which the other heirs did not object. That makes sense. It reasoned, even when the executor does not appear to defend the objection to some of the charges, if the party objecting cannot prove the invalidity of the charges, even those incurred over 20 years prior, the charges are deemed correct. Is this the rule of law when the executor claims he is owed over $500,000 from the successions, but he has never filed a claim as a creditor? How does a party defend against charges listed with a name and an amount, but no date and no location of property? How does a party defend against a claim for payment of credit card debt for miscellaneous items without even a year, much less a date? The only defense would appear to be an objection, as movers have done, pointing out these obvious facts to the court. Any prudent administrator, including executor, if he was acting as such, would challenge and oppose charges and expenses presented in the form and substance of much of what is included in the tableaus before the court. Can executor merely dump his 20-plus-year-old checkbook register into a tableau of distribution and expect the presumption of validity to apply and get payment? The irony is, there are no debts of either succession. This is all about reimbursement of money paid out, supposedly for legitimate expenses as defined in Article 1415. This court will and does take the position that the presumption of validity mentioned in Article 3244 must and should refer to properly filed and documented claims for expenses of death or administrative expenses as defined by the law. Other than those conceded by the movers, the items listed in the tableaus do not meet that standard. We cannot discern any legal error on our review of this matter. The record lodged in this court reveals a reasonable factual basis for approving only those undisputed expenses at this juncture. Considering the particular, unique circumstances occurring in this case, we cannot say the district court's decision to deny the remaining claimed expenses was manifestly erroneous or clearly wrong. For the award of costs against executor, appellants contend that the district court erred as a matter of law in assessing all costs against executor on the traversal proceedings. According to their argument, because the judgment approved some of the expenses, executor was successful on some of his claims and should have been assessed with costs. We disagree. Louisiana Code of Civil Procedure, Article 1920, governs assessment of costs and provides, unless the judgment provides otherwise, costs shall be paid by the party cast and may be taxed by a rule to show cause. Except as otherwise provided by law, the court may render judgment for costs or any part thereof against any party as it may consider equitable. Now, I'm going to read a footnote. Nothing in this opinion should be construed to preclude any future appointed executor from petitioning to homologate an amended and properly supported tableau of distribution or any opposing party from filing an exception of prescription or opposition pursuant to the dead man statute. And they cite that Louisiana revised statute bullshit. Back to the case. A district court is afforded great discretion in assessing costs, and such an award is generally only distributed upon a showing that the court abused its discretion. They cite some legal bullshit here, and it says, while the abuse of discretion standard is highly deferential, a court necessarily abuses its discretion if its ruling is based on an erroneous view of the law. And some other legal bullshit is cited here. Although generally the party cast in judgment should be taxed with costs, the district court has wide discretion to assess costs in any equitable manner and against any party in any proportion it finds equitable, even against the party who prevailed on the merits. And some other legal bullshit is cited here. And it says, as some courts have explained, a prevailing party may be taxed with costs if that party in some way incurred additional costs, pointlessly or engaged in other conduct which would equitably justify the prevailing party being assessed. And some bullshit is cited here. The record reveals long-standing delays and animosity among the heirs. Okay, so here we go. They have long-standing animosity at the time of this filing, and that was 2024. But in the previous documentation from the last live stream, it seemed on paper by around before 2019, it didn't look like the second generation was just divided, from my understanding. Perhaps I'm wrong, and there was other issues there that just were not made public at that time, but I am very curious as to what happened between then and now to make it like this, you know what I mean? Because although I am seeing more and more issues as to how they are fighting at this point, I still don't understand why. So then it says, the record reveals long-standing delays and animosity among the heirs, culminating in executor's removal. Siblings' resounding complaint remains that executor failed to provide any accounting in the 20-year period while the succession remained open, such that the expenses in dispute are largely unsubstantiated. Moreover, as siblings point out, executor failed to appear for the hearing on the motion to traverse and thus avoided the ability to be questioned on the nature of these expenses. The district could have reasonably determined that the executor engaged in conduct to incur the cost of the traversal proceedings. Under the circumstances revealed in the record, we find no abuse of discretion in casting executor with costs associated with the motion to traverse. Conclusion: for the reasons set forth in this opinion, the judgment of the district court is affirmed. Alrighty, so right now I'm just going to try and summarize only this case that we have been going over in the second portion of this live stream since the break. So just this case summary here. Basically, it looks like he had a legal dispute with his siblings over how he was spending the money from his parents' estates combined. It looked like there was an issue over the inheritance as it relates to both parents, but more specifically, there were debates and arguments about whether or not he loaned his mother any money. You know what I'm saying? And so, yeah, his siblings were basically arguing, in my understanding, in a nutshell, like, why the fuck would he have loaned our mother any money when our parents are the reason we have money? You know what I'm saying? In a nutshell. And they were basically able to prove in court that he had no evidence to back up some of the funds that he was claiming he needed them to pay him for. And he was trying to get over $500,000 from the estate. And that's a lot of money. And previously I had said, you know, I didn't think it was greed. I thought it was grief, you know, from why he was acting the way he was with other cases. But from this case, whenever you are trying to get over $500,000 out of your siblings, in my opinion, you know what I'm saying? At that point, it doesn't seem like it's about grief because you all share that grief. It can come off as greed. And that's just a superficial layer. I wonder if, though, how we got there, because he's an attorney. And at this point, we know that his license is in jeopardy. You know, he had his suspension from the state bar. So at this point, we know that he is really shooting himself in the foot. We know that, you know, in my opinion, I feel that it is so difficult to make it as an attorney. So I worked for 3 different law firms. One of the law firms that I worked for, this guy had a bunch of money and started the law firm from this money that he had access to, but he only had a certain amount of money to start up the fund with. And he was under so much pressure that he kind of, in my opinion, treated the employees like shit, because he was putting his pressure to profit on everybody else. And he ended up getting sanctioned by the state bar because of how he was mismanaging funds and relationships with clients. So then another attorney I worked for, she did really, really well with the road home program cases. But then the road home program cases had that statute of limitations on it, and that dried up. And so that was her main target market. And from there, she's someone who does not want to do most marketing. She does not want to run ads. You cannot convince her. She does not want to do a lot of things that you can do as an attorney to get clients, because she doesn't want to be predatory, which is what I love about her. But also, I feel like that aspect of her is what could make her really good at running ads if she did want to do it. But anyway, so she's decided to merge with another company, and her law firm is now merging with another law office because of how hard it is for her to make it as an attorney in this industry. And then a third attorney that I work for, the one that I filed a complaint against on the state bar with, I filed a complaint against the state bar with this attorney, and I filed a complaint on the EEOC with this attorney. This guy, he didn't build his own law firm. He purchased somebody else's law firm, if that makes sense. Essentially, it's more to it than that, but in a nutshell, you know what I'm saying? He didn't build his own business. He got his business from purchasing somebody else's work. You know what I mean? And so he doesn't have a lot of knowledge that it takes to build a business. And he doesn't really know how to run one, in my opinion, from, you know, my experience with him. So from these situations, I've seen how 3 different law offices built their career, how 3 different attorneys are trying to make a living. And from those 3 examples, and looking at the fact that Mr. Salvador Randazzo is an attorney, and he's going after his family for $500 million, not $500 million, $500,000, over $500,000, about $500,000. My bad. Apologies. Let's get that right. You know what the fuck I meant, right? Anyway, the fact that he's going after his fucking family for that, and the fact that he is an attorney, and the fact that he got suspended, I wonder if he's kind of having like an existential crisis with his career in relation to how oversaturated the legal market is, how difficult it can be to have sustainability in that market. You know what I'm saying? Because yes, king cake business is extremely
oversaturated as well, and an extremely difficult market to be profitable in as well. However, there are a lot less expenses involved with going into the king cake business than it is to be a lawyer. When you're an attorney, you know how much money attorneys spend on cases? Like, I understand to a point, some attorneys, they charge way too much. Some attorneys, they charge right what they need to charge, and some attorneys, they don't charge enough. They need to be making more money. You know what I mean? But like, just the amount of money you spend alone in filing shit alone is a lot of money. And I think a lot of people, they don't understand how much money attorneys spend on their cases. You know what I mean? But anyway, so in a nutshell, I am wondering if, after reading this case, before I previously thought it was a situation of grief from Salvador Randazzo with how he was acting, but after reading this case with his siblings, I wonder if it's not about grief, if it's about, it could be greed superficially, but deeper than that, I think it's tied to insecurity with his career and long-term financial stability. And I think that he's kind of self-destructing because I don't think that he feels secure in his own abilities. You know what I'm saying? Because if you were secure in your ability as an attorney, you would be working as an attorney. You wouldn't be focused on fucking with your family's assets this way, in my opinion. But anyway, I'm just speculating there. So that was my summary and kind of speculation from my opinions of recapping and processing that last lawsuit we just went over there. And that lawsuit was from the issue where Mr. Salvador Randazzo was removed as executor from his parents' estate by his siblings due to the possible mismanagement of funds. So yeah, so just to recap today's live stream, we have talked about quite a lot today. But first and most importantly, I want to remind you guys that, yeah, I did fucking see in that timeline that we went over around 1994, the second and third generation of the Randazzo King Cake family had gotten into a physical altercation. So if I can find any documents on that, I will cover that next. Also, what I wanted to cover, if I find any documents on it, Mr. Lawrence Randazzo, Mr. Salvador Randazzo's father, had sued his nephew, Mr. Manny Randazzo Jr., but that lawsuit got dropped. If there are any public records available for that, I'll cover that too. So today we went over basically the family history of the Randazzo family. We checked out the websites from what is published from the Randazzo family, how they all have in common the original Mr. Salvador Randazzo, how that family roots come from him making a living for the family, building a business for the family, for the future generations. And we discussed how I do hope this entire family reconciles, and how I do hope systems are put in place for this family to be able to secure their company for the future generations of the family, and set it up in a way to where if the future generations are fighting, there are procedures in place for what should be done so that they can stay together, so the business keeps them together and doesn't tear them apart. You know what I'm saying? Because the business is here to support the family, right? We actually went into the article. So I had been using this NOLA.com article because they have a good family tree. So we've been using that family tree diagram to reference for who are we speaking about. I actually read the article in this stream. We hadn't read it in the last two, but that's where I got that timeline from that really outlines the legal disputes and the physical disputes from the past. And then last but not least, after all of that, we went through 3 different court records available. 2 of those records were on the same case. So first we looked at Randazzo versus St Bernard Parish Government. We looked at both the case summary and the actual case material itself. And in that case, that is why I ended up doing this live stream today. So first, I did a live stream on Mr. Salvador Randazzo because I was looking into my own disciplinary counsel complaint situation, and in that situation, I saw Mr. Randazzo's suit, or is it a lawsuit if the disciplinary board suspends you? Anyway, I saw his suspension and I read that case and I was fascinated by it, and so we reviewed it. In that case, he was talking about he got suspended because of a different case with his family. So in our last live stream, we looked at that. And in that case, he was trying to stop his family from settling with St Bernard Parish. And he was using this case that we discussed today as why. And today we looked at the case of Randazzo versus St Bernard Parish Government, where St Bernard Parish Government had demolished his family home. So yeah, so we looked at that. And then last but not least, we looked at the succession of Lawrence J. Randazzo and his mother, Josephine Randazzo. That's not Lawrence's mother, that's Salvador Randazzo's mother. Apologies, that was Lawrence's widow. We looked at their succession, and we looked at how Mr. Salvador Randazzo's siblings basically got him removed as executor of the estate because they believed he was mismanaging the funds. And we're here now. So yeah, so thank you for joining me today. It really means a lot to me. I'm gonna go do some digging on that paperwork. Maybe I'll go live today if I feel up to it. I don't know if you've noticed in this live stream, my voice is a little off, but I might end up going live. If not today, maybe I'll go live tomorrow or something. But I'll go live again soon if I can find any public records on that physical altercation. I'll definitely cover it. But yeah, and the other lawsuit that got dropped, if I can find any record, I'll cover that too. So yeah, thank you for your time today. I appreciate you. It means a lot. I think this might be the most people that have ever joined a live stream of mine while it was live. So thank you guys for watching. That means a lot to me. I appreciate you. I hope everything works out for everybody and keep the family businesses going and all that good shit. Bye. Thanks for watching. Join the loyalty program at noladeafchild.com/loyalty and check in during live streams to get points for rewards.